Hi guys, good evening. Good afternoon guys, kya hal chal? Okay, am I live now? Yes, it is. So people are joining. Okay. So let us start the class. Okay. My screen is visible to each and everyone. Okay, guys. Today we are going to start our rapid revision batch for the students who are appearing in exams just right now. उनके लिए, and this contract act is a special act which is very important for your examination point of view as well, for your each and every paper, each and every exam in pre, in mains, everywhere, everywhere. Now almost every one of you has done this Indian Contract Act in your law school, in your university, first year, first semester, everywhere. But when we are discussing this Indian Contract Act from the perspective of this competitive papers for judiciary exams, so certain points need to be taken care of, some tricky points, some important questions need to be taken care of. That's we are going to study specifically in this session, which we is going to start now from 1 to 3. Okay. Give me a thumbs up that my screen is visible to each and everyone. Voice is clear. Give me a thumbs up. I'm keeping a track. Okay, let me see. Is there any issues with anybody? Just give me a moment. Okay. I think it's perfect with each and everyone. Kindly write it in the chat box. If you have any problem during the session, if you have specific doubt during the session, just write it down in the chat box. Okay. Now we are going to start Indian Contract Act 1872. Indian Contract Act 1872. Now, almost every one of you know that what is a Indian Contract Act and what is Indian contract. First thing you need to understand the nomenclature, that is contract. We have studied many times that a contract is an agreement which is enforceable by law. So basically, if we break the contract into two essential elements, number one is agreement, number two is enforceability. Enforceability means intention to create legal relationship. Intention to create legal relationship. One thing important, guys, like today we are going to discuss this Indian Contract Act. So whenever you are appearing in any examination, either it is subjective paper or objective paper, always focus upon the keywords. Always focus upon keywords in subjective paper specifically, because the examiner is looking for those keywords, and he'll be more than happy to give you marks when you write those expected answers. Number one. Number two, when you are appearing in the competitive exams where the question paper is of objective in nature, so there might be a possibility where the four options are of such a nature that they are quite overlapping, quite confusing. So always focus that in under which option you are getting a keyword. That would be the most suitable answer, most probably. Apart from the entire option, always look for the keyword. Okay. Now, when we are doing for enforceability concept, the meaning is there is an intention to create a legal relationship. The parties to the contract are having an intention to create a legal relationship. The first and foremost case which we did, Belfer versus Belfer, where the husband went to Sri Lanka and refused to give money to his wife. So the court held that there was no intention to create legal relationship among the parties, so it is not a contract. It may be an agreement, but it is not a contract because the lack of the absence of this element. Number one. Number two, sir, there might be a question, there might be a situation in the mind of students that every time when the parties are in such a relationship, say near relationship, husband wife, father son, so there will be always a confusion regarding enforceability. There will not be enforceability in these contracts. No, this is not the answer. General rule is this, but we have done numerous situations where even the parties were having the the proximate relationship. The parties were in the proximate relationship, near relationship. Even then, even then, there is an intention to create a legal relationship in this case. In that situation, the very famous case of merit versus merit, merit versus merit. Now, this merit and merit were husband and wife, where the property was uh, agreed to be transferred in the favor of wife, provided that she will pay all the outstanding amount of the flat and the property. Now in this contract, their intention was to create a legal relationship. So if there is a concept regarding enforceability, if there is a question regarding enforceability, case study, so please pay focus upon this concept, that it is not necessary that whenever a parties are in proximate relationship there will be no contract. No, it is not. Okay, now one more thing, this enforceability concept is very important for your examination point of view as well. Okay, now sir, when we talking about agreement, what is an agreement? Agreement, sir, when we are intending to when we are giving an offer among two different parties, and acceptance has been given for a consideration, for a capacity to contract, for free consent, all these are the essentials of a valid contract. All these are essentials of valid contract under section number 10. If any of these essential is missing, the contract is not valid. The contract is not valid. Now before we go ahead, there are 3 4 terms which you need to keep in mind: valid contract, void contract, voidable, and illegal. Now, valid contract is that contract which is fulfilling all the essential, all the requirements as enshrined under section number 10. जो भी इसके अंदर essential ingredients है, though all those ingredients have been fulfilled, the contract is valid. Void means null, zero, no legal existence. So if any agreement is having not having capacity to contract, the person were not capacity competent to contract, the consideration was not lawful, or even the consideration is not there, in that eventuality we will say the contract is void. What is voidable? Voidable is a situation where you are standing at that edge of a road, that either you have to make the contract valid or void. It is, the ball is in your court. Your means the aggrieved party. The aggrieved party is to choose the decide the fate of the contract. This is known as voidable. This is known as voidable, that you have to decide, you have to choose the fate of the contract. Okay, now you can make the contract valid or void as it is your desire. It is purely your desire. You are at this point. Next is illegal. Illegal. Now many of students can't differentiate between void and illegal agreements. Sir, almost they are same. No, they are not same. They are different. They are different. The basic difference is, if the contract, listen to my words very carefully. If the contract is void, if the contract is void, it will bear no effect upon the collateral transaction. If the contract is void, it will bear no effect upon the collateral transactions. But if the contract is illegal, if the contract is illegal, that subsequently collateral transactions are also void. Collateral transaction will also become void if the contract is illegal in nature. So understood? So therefore, when you are marking an answer in your paper, please pay attention while marking, that either you are choosing void or illegal. Don't think both are same. No, they are not same. They are not same. Okay, now next, sir, what is the basic of agreement? Many of you have might be having a question, and that is quite obvious. Basically, in each and every contract, the basic starting point is offer. Second is acceptance. Offer and acceptance. The person who is making an offer, he is known as offerer. To whom it is made, it is known as offeree. Similarly, he will be known as acceptor, acceptee. So one thing you need to keep in mind, that under Contract Act, under Indian Contract Act, there is no word of offer. It is a proposal. It's a proposal. However, we use the term offer, but if both options are given, so prefer the option proposal. Now, what is an offer? Offer means when you are conveying your desire with a purpose to communicate and with an intent to accept it, with an intent. Now you read, when you read the definition of offer, it says when a person signifies to the other person his willingness to do something or to abstain from doing thing. Now here the word is signifies means communication. So for a valid offer there must be a communication. अगर आपने मन में सोचा, if you are thinking in your mind, then it will not amount to a valid offer. For a valid offer there should be a communication to the right person. A communication of what? Communication what you intend to do or what you do not intend to do, that has to be done through to the right person. Why you are doing it? The purpose, the objective is to obtain his assent means acceptance. Now once offer and acceptance are combined together, it will give a birth to a valid promise. Okay, sir. Now we let us go to acceptance. Acceptance means that whatever the offer was conveyed to the party, he is simply saying yes. Okay, fine. Let us enter into a contract. Your accent, then it will amount to a valid acceptance. But what if he is negotiating? For example, Rahul Jain sir is talking to Abhishek. Abhishek, will you sell me your phone for 50,000? He said, no, sir, 60,000. As soon as he said 60,000, this becomes a counter offer. And as soon as counter offer is given, the previous offer stands revoked. Now, this term you need to keep in mind, counter offer. Many people gets confused between counter offer and cross offers. Cross offers means when two parties are telling the same thing but in different sense. How? Rahul sir is saying to Abhishek, Abhishek, will you sell your phone to me for 50,000? At the very same time, Abhishek is also saying to Rahul Jain sir, sir, will you purchase my phone for 50,000? The terms and condition are same, but here he is making an offer. In the previous one, Rahul Jain is making the offer. That is known as cross offer. So always keep in mind the difference between cross offer and counter offer. Now, similarly, offer acceptance may be expressed as well as implied. Offer acceptance must be expressed or implied. Express means when you are conveying it by specifically your words. In implied form, it may be by way of your conduct, your gestures, your movements, your action. Okay. Now, sir, similarly, by like the offer, there should be a communication of acceptance. It is not like कि मैंने मन में सोचा था, I just thought in mind. No, the communication of acceptance must be there to create a valid contract. Remember the case of Feldhaus versus Bindley. Number two, not only communication to be made, communication to the right person and by the right person should be there. Remember the case of Powell versus Lee, that there should be a communication by the right person, communication of acceptance by the right person and to the right person. So this thing is to be noted. Now, sir, you are again and again saying communication. Now, communication plays a pivotal role in the case of offer and acceptance. What is communication? Communication means, sir, communication means conveying. Okay. Now we have two parties, offerer and acceptor. Point to be noted that communication is offer is complete when it comes to the knowledge of the acceptor. Or offering. एक ही बात है. However, when we are talking about communication of acceptance, it is divided into two parts. As against the offerer and as against the acceptor. Now, the communication of offerer, again, communication of acceptance against the offerer is completed when it is put in the course of transmission. That means it is beyond the control of the acceptor. As soon as the letter of acceptance has been put into the red letter box, that means it has now become out of control. then offerer is bound. But as against the acceptor, the communication is completed when it comes to the knowledge of offeree, when it comes to the knowledge of offerer, sorry, when it comes to the knowledge of offerer. So, ऐसी इन दोनों situation में the acceptor can revoke the contract before it reaches to the offerer. Number one. However, offerer can revoke the contract before the letter is put into the course of transmission. Before the letter is put into the course of transmission. Okay, understood? Okay. Next is, sir, one thing you important you need to keep in mind that advertisements are invitation to offer, invitation to offer, advertisements, invitation to offer, tenders, the display of items in the supermarket on shelf, display of dresses in the showroom on the glass window. These are just invitation to offers. These are just invitation to offer. Supposedly, in the case of tender, there is an advertisement by government of India that who wants to construct this road and play apply. Now, this is an advertisement. It is an invitation to offer. When you are filing the tenders, it becomes the offer, and when the government is accepting it, your bid, it becomes acceptance, and the contract is formed, okay, understood? ये चीजें आप लोगों ने ध्यान रखनी है. कम्युनिकेशन very important, invitation to offer very offer, and again the acceptance must be absolute, unqualified. If it is conditional acceptance, then it won't amount to a valid acceptance. Why? Logic is it will become a counter offer. It will become a counter offer. Now, one thing important to be note, that acceptance should be given in the prescribed manner if it is specifically given, otherwise in the usual course. For example, Rahul Jain sir obtained a letter of offer letter from Losico that you have been hired as on this designation. If you want to accept this position, please mail us within 15 days. Now Rahul sir is super intelligent. What he did on 16th day, he just joined the office. The owner of Losico is saying, sir, what are you doing here? Sir, you gave me an offer letter. I am here for job. Sir, did you reply? No, sir. Why? Sir, I WhatsApped you. No, brother. We have specifically stated that if you are apply, if you want to accept it, just mail us, and that too within the prescribed period of 15 days. Within the prescribed period of 15 days. After the elapse of this 15 days, the offer stands automatically revoked due to lapse of time. Due to lapse of time. If you want to accept the offer, you have to mail it within that prescribed period. If it would not have been this situation, then in that situation, the reasonable manner, in a usual or a reasonable manner. Okay. Okay. Any doubts up to here? Any doubts? Please write it in the chat box if you have any doubts. I'm waiting for a minute. I'm waiting for a minute. Please, if you have any doubts, just see to your notes and your books, your bare acts who are doing revision side by side. Okay, I guess no doubts. चलते आगे. Now, very important consideration. Consideration. What is consideration? Sir, consideration is the heart of any contract. Consideration is the heart of any contract. Now, under consideration, section 2D definition, the consideration should be given at the desire of the promisor. Number one, at the desire of promisor. Now, number one is that consideration should be given at the desire of the promisor. आप अपनी मर्जी से नहीं कहेंगे. Very important point. Consideration may be given by the promisee or any other person. Or any other person. Section 2D is specifically saying that the consideration can be given by the promisee himself or by other person. For example, Rahul Jain sir enrolled in a batch of Law Seco and Law Seco is demanding the fees. Now my friend Mukesh Ambani wants to pay the fees. He said, "Who are you?" Losico said, "Who are you to pay the fees? We demanded fees from Mr. Jain, so Mr. Jain will pay the fees." This is not done. This is not done because Section 2D is specifically saying that consideration may be given by the promisee himself or any other person. By the promisee himself or any other person, it does not make any difference. It does not make any difference. Okay. So this is known as privity of consideration. However, under English law, the consideration has to be given by the promisee himself, but not in under Indian law. So इस चीज को याद रखना है. And the landmark case is Chinnaiya versus Ramaiya. Chinnaiya versus Ramaiya. Okay, just remember this thing. Okay, okay, Shaktija, shall we give me a thumbs up? Okay, I guess fine. चलिए. Now consideration may be positive or negative. Positive or negative. That what does that mean? It means consideration may be to do something or to abstain from doing something, or from abstain from doing something, and it may be past, present, and future. Past, present, and future. The consideration may be past, present, and future. Okay, but one thing is to be noted that under English law, past consideration is no consideration. Under English law, past consideration is no consideration, but under Indian law, the law is recognizing past consideration, present, or future, all the three times. Okay, fine. Next point to be noted in the chapter consideration, which is very important for your examination point of view, is that the law regarding section number 25. Section number 25. Section number 25 is saying that any agreement without consideration is void. Any agreement without consideration is void. This is the general rule, but this general rule is having three exceptions. Number one, natural love and affection. Number two, past promise to pay voluntary services. And number three, time barred debt. Now let us understand. Now number one exception is if the parties are in relation of proximity, near relationship. Number one. Number two, and due to that natural love and affection, there has been a promise, and that promise was in writing as well as registered. Writing as well as registered. In such an eventuality, it even if there will be no consideration, even if there will be no consideration, then also the agreement is valid. Then also the agreement is valid. It cannot be said void due to lack of consideration. 3 points yaad rakhne hain. Number one, the relationship between the parties was such, the promise was made out of natural love and affection, in writing and registered. In writing and registered, then it will fall in the exception of section number 25. Okay. Now there was a case of Rajlaki Dabi versus Bhutnath Mukherjee where the parties were in relationship and the promise was written as and registered, but that promise was not given due to natural love and affection. That was given out of quarrels, fights. Then in that situation, it will not be allowed to take a benefit of this exception. Okay, number one. Number two, compensation for past voluntary service. Compensation for past voluntary service. Now, when someone has given a past voluntary service, like Rahul Jain sir went to a restaurant and forgot his mobile there or a wallet there, and a waiter comes to me, "Sir, you forgot your wallet." And I said, "Oh, thank you so much. It was having so much important documents and cards. I'm very thankful to you. I will pay you 500 rupees, 5,000 rupees later on." Now, this is a promise. This is a consider. Even if without the consideration, then also it is a valid. It's a valid. Number three, time barred debt. When there is a promise to pay a time barred debt, wholly or partly, but that promise must is in writing and signed, then it is a valid contract, even if without a consideration. Even if without a consideration. Okay. Sir, what is time bar debt? A time bar debt is a debt which has been hit by the limitation period. Which has been hit by the limitation period. Okay. Now, One important question regarding consideration is there, which I have told you in the class as well, and many times इसको हमने बहुत डिटेल में करा है. What about charity, donations, subscriptions? What is the rule regarding that? Now, Mr. Rahul Jain was approached by two persons. Was approached by two persons. Number one, Mr. X and Mr. Y. Mr. X came to me for donations for Gaushala. Sir, we are having an NGO. We are indulged in constructing a Gaushala and maintenance of that. Okay, I promised them to give 5,000 rupees. Okay. Number two, Mr. Y came to my office, sir. We want to construct a community hall for the community for poor people. And okay. Now I said, okay, I'll give you 50,000 rupees. You start creating community hall. Now, in both the cases, I've refused giving the payment. In situation number one, there is no consideration. Why, sir? Why? Isliye, because in situation number one, I am just giving a donation. Upon I am giving a promise to donate something, but nothing has been done on behalf of X due to that. In situation number two, I gave a promise to pay for 50,000, but and upon that promise, Mr. Y started construction of community hall. Check construction शुरू हुई है, whether they have contracted the contractor, architect, just started, foundation stone has been laid, कुछ भी हुआ हो. So that job is the consideration in return. So in situation number two, it is a valid contract. In situation number one, it is not a valid contract. The landmark case of Kedarnath versus Gauri Mohammed. Okay. Okay, chaliye ji. Next, with this, we are done with this chapter. Consideration. Any doubts? Any doubts in consideration, guys? Otherwise, let us start our next chapter. Any doubts? Just give me yes or no. I'm waiting. Shaktija, Manish. Okay, I guess no doubts. चलिए, next topic is capacity to contract. Very important for your examination point of view, specifically pre-paper. Now section number 11 of Indian Contract Act is talking about persons competent to contract and talking about three situations. Number one, a person who has not attained the age of majority. Number two, unsound mind. Number three, disqualified by law. Disqualified by law. Three categories. Now, one thing I always say that you need to keep in mind that Indian Contract Act is nowhere giving you the age limit. Indian Contract Act is nowhere specifying 18 years. It is simply saying that who has not attained the age of majority as per the law to which he is subject. Now, under Indian law, it is Indian Majority Act 1875, and the present position under this act is a person who has been given the age of 18 is will be known as adult, and if the guardian has been appointed by court, then in such an eventuality, the age limit is 21 years. If tomorrow this is reduced to 16 years or 19 years, whatsoever the situation is, then that will be applicable. Indian Contract Act is not giving the year exactly. Okay, so you need to keep in mind while attempting a pre-paper, there might be a tricky question on this point. Okay. Number two is unsound mind. Mind means what do you mean? Now, again, important point to be noted. Indian Contract Act is nowhere giving that a person is suffering from ailment or a particular disease or something like that. It is simply saying who will be considered as a person of unsound mind, that at the time of making the contract, if that person is unable to understand the terms and conditions of the contract, and he is not able and he is not fit enough to deduce the result of that contract, he is not able to make a rational judgment, we will consider him unsound mind. So by this virtue, we can say that unsound mind and drunk person is on equal footing, क्योंकि नशे की हालत में उसको समझ नहीं आ रहा है, is not able to understand the terms and condition, then yes, he will be considered as unsound mind. And one thing important, that it is at the time of making the contract. Supposedly a person was fit enough at the time of making the contract, but later on was hit by some ailment or some medical disease or whatsoever situation is, then the contract is not affected, because at the time of making the contract has to be considered. So there is a question in paper that some different timeline is given, you have to focus upon this time only, that what was his mental state at the time of making the contract, बस ना आगे का देखना ना पीछे देखना. Okay. Now, sir, what if a person who is a minor who has not attained the age of majority? Will he be considered? What will be the fate of that contract? The general rule is, in any of these situations, the contract will become void. This is the bottom line. This is the bottom line. Now, when you are preparing for this minor concept, you need to keep in mind four cases, very important. Mohri Bibi versus Dharmodas Ghosh, Leslie versus Shield, खान गुल वर्सेस लखा सिंह, सर शादीलाल इसमें थे, एंड अयोध्या प्रसाद वर्सेस चंदन लाल. Ajodhya Prasad versus Chandan Lal, and the conclusion. Now, one thing, when you are appearing in subjective paper, you need to give time and space to all these four cases to develop your best answer, the model answer. In Mohri Bibi case, it was held that the contract is void. Number one, no relief under section 64 or 65 under Indian Contract Act. However, law commission recommended an amendment in 65 to cover certain cases, but still no such amendment has been there. Last point, that no relief under specific relief act as well, because the money lender knew about the age of minority at the time of making the contract. Okay. Khangul Lakha Singh, Shadilal, and Ajodhya Prasad gave two different opinions, which was sorted by the later on. And finally, the bottom line was that when a minor goes as a plaintiff for cancellation of instrument, it may कोर्ट में ऑर्डर टू रिस्टोर द बेनिफिट एज जस्टिस में रिक्वायर. याद रखना, if minor is going as plaintiff, then restoration as justice may require. Number one, if he is going as defendant, then up to the extent his estate was benefited, up to the extent as the state was benefited. Number next, Leslie versus Shield is not applicable in India. ये तीनों पॉइंट याद रखने हैं, पेपर में आते हैं, that what is the bottom line in India regarding minor concept. However, this is untouched, this is final, that any agreement with minor is void. Okay. When we are talking about minor, you need to keep in mind under Indian law that a contract with minor with regard to apprenticeship is valid. With regard to service is void. A minor may enter into partnership but for benefits as per section 30. A minor cannot be a principal. A minor can be an agent. बट नॉट प्रिंसिपल. ये क्वेश्चन कई बार आ जाता है, स्टेटमेंट 1 इज ट्रू, स्टेटमेंट 2 इज ट्रू और नॉट, इस चीज को याद रखना है. ओके, अंडरस्टूड. चलिए, एनीवन एल्स इन दिस टॉपिक on capacity to contract? Any doubts? I guess no doubts. चलते आगे. चले, Very next topic is free consent. Free consent. Now, one thing you need to keep in mind while attempting your paper under Indian Contract Act, mere consent is not sufficient. It should be free. It should be free. Consent means when two persons are agreeing on something in the same sense. Same thing, same sense. If there is no consent, the contract, if they are not agreeing on the same thing, on the same sense, it becomes no consensus ad idem. No consensus ad idem. And as per section 20, the contract will become void. The contract will become void. So remember the case of peerless case, Vishal Raffles versus Vishal House. Raffles versus Vishal House. Now, sir, consent to hai but free nahi hai. We have a consent but not free. Then also it is of no good for us. We need consent as well as free. Sir, what is consent and what we have understood what is consent? How it is free? If the consent is said to be free when it is free from coercion, undue influence, fraud, misrepresentation, and mistake. In first four situation, the contract will become voidable. The contract will become voidable as per section 19 and 19A respectively. However, in the last situation of mistake, the contract will become void as per section number 20, 21, and 22. Okay. Sir, what is coercion? When you are committing any offense or threatening to commit any offense, any act forbidden by law, or unlawfully threatening to detain the property, then it will said to be coercion. Now, when you are understanding the concept of coercion, you need to keep in mind that this is a limitation of coercion. That coercion is covering only the offenses which is covered by IPC. There might be a question in the paper that there is an offense which is not punishable by IPC but by some other offense, by some other act, then it will not be covered as coercion. ये याद रखना है, ये याद रखना है that there, if there is an offense which is not punishable by IPC but by some other law, then it will not be covered by coercion, because in coercion they have specifically used the word IPC, Indian Penal Code. However, due to this reason only, we Law Commission has given the suggestion to include other laws as well. But till now, the position is same. You have to be stick towards IPC only. These are some guys slippery points. यहीं पर पैर लड़खड़ाएगा, क्वेश्चन गलत होने के चांस बनते हैं, और आता जाता क्वेश्चन गलत हो जाए बहुत ज्यादा दुख होता है. Okay, so please keep this thing in mind. Now, coercion can be done to any person. It may be the party to the contract, his relative, or even stranger. Indian law is considering everything. Indian law is considering everything. This is a point of difference. Both the points of difference are there in concept of English law. English law में वो कहते हैं any law. If it is an offense under any law, then it is a coercion. They are saying the coercion must be done to the party to the contract himself or near relative. They are not considering strangers. They are not considering strangers. Okay. Not only the parties, we are considering property as well. We are considering property as well. So if a threat or injury to property has been made, then it will also amount to coercion. And as it is written over here, if the consent has been obtained by coercion, we will say there is no free consent and the contract will be voidable. Remember अभी हमने क्लास की शुरू में करा था what is voidable. Voidable means those contracts where the aggrieved party has to decide the fate of the contract to make it valid or void. Okay. Point number 2, undue influence. Undue influence means when the parties are in such a position where one party can dominate the relationship, can dominate the will of another. And second point is this position, this dominant person has used that position to get an unfair advantage. To get an unfair advantage. The position may be due to real or apparent authority, fiduciary relationship fiduciary relationship, or due to mental or bodily stress. Mental or bodily stress. This is the flowchart. Two ingredients: position. Position is divided into three categories: real or apparent authority, fiduciary relationship, or mental or bodily stress. And the person who are in the dominant position has used that position to take the unfair advantage. Remember the case of Manu Singh versus Umadat Pandey, where a spiritual guru was taking an advantage. Remember, I used to give an example of sacred grapes, Aham Brahmasmi. Okay, number one thing. Number two, if this is the situation and the terms and condition of such a nature, we will raise a presumption of unconsignable bargain. When there is a dominant position and the terms and condition of the contract are such a nature, then law will take a presumption of undue influence in the case of unconsignable bargain, and under that eventuality, the defendant is under burden of proof to rebut that argument. It is the burden of proof. The onus is shifted towards the defendant, not to the plaintiff. Remember the case of Niko Devi versus Kirpa, Takri Devi Ramadogra, Dailaram versus Sarga. Dailaram versus Sarga. Okay, these three cases we have done. Okay, understood regarding undue influence. Third is fraud. When you are intentionally deceiving another party by making a false statement, or making a intentionally concealing a fact, or any other fact which is fitted for it, or any other act which is created designated as the fraud in some other law, that is known as fraud. What is the difference between fraud and misrepresentation? The basic difference is intention. The basic difference is intention. If there is a malified intention, then it will be as a fraud. If there is no intention, but however we have said a false statement, we have jhoot bola hai, that under that eventuality, it will be known as misrepresentation, not fraud. Misrepresentation, not fraud. So if a consent has been obtained by any of these four elements, we will say it is not a free consent, and the first aggrieved party is entitled for voiding the contract just because 19 and 19A. Understood. चले आगे. Okay, give me a thumbs up. Sir, बार बार thumbs up मांग रहे हो, will give you a cold drink. No, just this thumbs up, that like button, that yes. Okay, we have understood. Those who have just joined, just say hi. Those who have just joined the class. Any doubt, Manish, up to this? Shaktija, Shelvi ma'am, any doubts up to here? Now guys, one thing specifically, जितना हमने अभी तक करा है, whatever we have done just now, these are the most important topics for your paper. These are the most important topics for your examination point of view in your pre-paper. Please do not leave these chapters और ऊपर से कर लिया, नहीं, ऐसा नहीं है. These are very very important chapters. Okay. Apart from that, I told you that there should be a consideration under 25. If it is not there, the agreement is void. Now, law says that it is not sufficient that there is a consideration. The consideration must be lawful as well. The consideration must be lawful as well, as per section number 23. That if it is forbidden by law, if it is defeating the provisions of law, if it is fraudulent, or if it is immoral or against public policy or injuring someone, then it will be unlawful, and in that eventuality the agreement will become void. The agreement will become unlawful. Agreement will become void because the consideration was unlawful. Okay, now very important chapter is void agreements. Apart from these situation, even if there is a contract which is fulfilling all the essential ingredients as per section number 10, no matter all the essential ingredients have been settled down, has been fulfilled, but law has created a list which is known as expressly declared void agreements. expressly declared void agreements. That means even if all the essential ingredients of section number 10 are fulfilled, but that agreement is falling under this category, in such an eventuality, the contract is void. The contract is void. सर सबसे पहले तो agreement without consideration वो हमने पढ़ लिया. In restraint of marriage, in restraint of marriage. Remember the older movies where the father of a girl used to say, "Take this money and go out of the life of my daughter. Don't show me your face. How dare you to enter into a relationship with my daughter? Have you checked the status?" That older movies. Now in that situation, the contract between the father and the boy is was will fall under this category of agreement in restraint of marriage under section number 26, and it will become void, and it will become void. Similarly trade, but there are certain exceptions with regard to trade sir. ऐसे तो हम लोग exceptions लगाते हैं, like sale of goodwill. When supposedly Haldiram is a brand, he's having a goodwill, or if he has sold his business to someone, everyone in the market cannot use the brand of Haldiram, because that goodwill is with particular person. If there is a contract of service, remember the movie Fashion, Meghna Mathur. Panache entered into a contract with Meghna Mathur that till the time you are modeling with us, you will not be entering into any contract with any other ad agency. That's a contract of service. That's a contract of service. Now there are certain situations where under Indian Partnership Act, there is a situation where you are putting a restriction that you can do it from Indian Partnership Act. Apart from that, trade combinations, solus agreements. In many books, you will find like trade combinations are there, solus agreements are there. Sir, for example, Government of India entered into a contract with Rahul Jain that you have to supply me the ink used for voting, which we put it on our finger. Now you will not give this particular ink to anyone else. This is a contract between Government of India and that ink manufacturer. Now that's a soulless agreement. It will fall under the exception. You cannot take a plea, मेरा तो काम धंधा मैं तो सबको दूंगा ये ink. No. That's a soulless agreement made for a particular purpose. So that ink will be supplied to Government of India. Okay. Next is agreement in restraint of legal proceedings. Agreement in restraint of legal proceedings. If you are putting a bar to the legal proceedings, it will not amount to a valid contract. Now, when you are doing this particular topic, you need to keep in mind arbitration clause is an exception, because arbitration is not giving a, and it is not putting a restraint over the legal proceedings. Or rather, it is giving an alternative remedy. It is giving an alternative remedy. Number one. Number two, in many contracts, there is a jurisdiction clause that all disputes with regard to this contract is under exclusive jurisdiction to the courts of Delhi only. Now, in that situation, you are choosing a particular jurisdiction of a court, then it will be a valid. It is not a agreement in restraint of legal proceedings. But here it is point that supposedly you are having you and by CPC you are having New Delhi, Bangalore, and Mumbai. These three options were there for jurisdiction. Now you have chose Chandigarh as jurisdiction. This cannot be done. This cannot be done. You have to choose any one of these three, or any two of these three, or even three. इनसे बाहर नहीं जाना. आप अपनी मर्जी से सीपीसी के प्रोविजंस नहीं लगाए, मोड़ तोड़ करेंगे. If CPC is giving you jurisdiction either in New Delhi, Bangalore, Mumbai, according to the case, then you have to choose among these things only. This is not the agreement in restraint of legal proceedings. Understood? Understood? Okay. Wagering means betting. Betting. That means wagering agreement are those agreements where there is a point, there is an opposite view regarding an uncertain event. Uncertain event. Number next, both the parties are having a chance of gaining or losing. Gaining or losing. Last, they are having no interest except this gain or lose. Except this gain or lose. Okay. one thing, two, three things you need to keep in the concept of wagering, because wagering is very important topic. Wagering is very, very important topic. Yes, in Punjab, UP, Bihar, Delhi paper, wagering topic is coming again and again. And this section number 26 and 27, guys, you can note it down in your notebooks, in your books, whatever you are jotting it down. Section number 25, 26, 27, 29, 30, and in fact 23. Very, very, very important. Write as many V's as you can. 23, 24, 25, 26, 27, 29, and 30. Very important sections for your paper. Very important sections. Don't miss them out at any cost. Okay. Okay. Sir, what is the scope of wagering? What is the present status? Now, listen to my words carefully. Since it's a wagering agreement, the agreement is void. Agreement is void. That, what does that mean? What does that mean? That means if a person has been declared winner of a prize money in a lottery ticket, he cannot sue the party for recovery of prize money. That has been held by the famous case of Shekhar Chand Jain versus Ram Narayan. Okay. Okay, number one thing. Number two thing, sir, there should be a, for considering now, sir, like in movies like Dangal movie में क्या हुआ, that the wrestler who will win the fight, he will get 80% of the proceeds of ticket. The person who will lose the fight, he will get it 10%. Now this is not winning or losing. This is not wagering. This is not wagering. You need to keep this thing in mind. Wagering क्या होती है? Betting. Betting. Wagering is betting. So while determining that whether it is wager or not, you need to keep thing in mind. Okay. Okay जी, चलें आगे. Okay, चलते हैं. Next topic is contingent contracts. Next topic is contingent contracts. Contingent contracts are those contracts, the simplest topic, which are dependent upon happening or non-happening of a certain contract, certain event, uh, to within a specified period or within not a specified period. Then it is known as a contingent contract. Sir, if there is a contract based upon an impossible event, is it a contingent contract? ध्यान से समझिए. Supposedly Rahul Jain entered into a contract with Abhishek that I will give you 1 lakh rupees if Pandit Jawaharlal Nehru becomes the Prime Minister of India. What would be the fate of this contract? I entered into a contract with Abhishek which is dependent upon a event which is impossible. That Pandit Jawaharlal Nehru का प्रधानमंत्री बनना impossible है because he is no more. He is no more. Then what would be the fate of this contract eventuality? Write down the answer in the chat box. If you are making the contract based upon an event which is impossible, which is impossible. Write it down quickly. Okay. Now, if in this situation the contract is void, the contract is void. This point you need to keep in mind that doing an impossible act is also void, but an agreement which is dependent upon an impossible event, it is also void, and it is immaterial whether the parties of the contract knew about such impossibility or not. It is immaterial. अभिषेक फॉरेन से आया था, उसको पता ही नहीं था जवाहरलाल नेहरू जी की तो मृत्यु हो चुकी है. He didn't know about the fact. फैक्ट पता था कि नहीं पता था, it does not make any difference, and the contract is void. Okay, understood? Next is any contract is made for performance. Any contract is made for performance. Now when you are making a performance or you are giving an offer to perform, when you are giving an offer to perform, that is known as tender. That is known as tender. And what are the valid essentials of a tender? The valid essentials of a tender is The tender must be unconditional. It should be at proper time and place. The promisee must be given an opportunity to ascertain that whether the goods are in consonance with the contract, and he should be given sufficient time to check it. And if there are number of joint promisees, the offer of promise must be may be made in the favor of any of them. These are the essentials of valid tender. These are the essentials of valid tenders. Okay, understood? Understood. But when we are talking about performance of the contract, that's there is a essential topic of time. You need to ascertain whether time was an essential ingredient of that contract or not. If time is an essential ingredient of that contract and that contract was not performed within that stipulated period of time, then the party is having a right to avoid the contract. But if it is if the situation is such when the contract in the contract the time is not the essence, time is not the essence, then you cannot avoid the contract, but only you can claim some damages. Okay, now in that case you can understood the point of reciprocal promise. Reciprocal promise means there is a concept, sir. Rahul Jain ordered Abhishek publishing house for supply me of some sample papers. Supply me of some sample papers. Abhishek said, sir, please give 10,000 rupees as advance. Now Rahul Jain is under a duty to give rupees 10,000 advance. This is known as reciprocal promise. This is known as reciprocal promise. If Rahul sir is not giving the advance money, Abhishek is also not bound to supply the sample paper, because one party is preventing the other from performing his reciprocal promise. He's preventing it. Okay, okay, understood. In this chapter you need to pay focus upon the minor, very simple topic of appropriation of payment. Supposedly Rahul Jain sir is a regular customer of Abdul soda shop. Now every week I go to his shop and give him 500. Now against which bill he has to adjust it. This is known as appropriation of payment. This you have to keep in mind. First, appropriation as desired by the debtor. Debtor means who is giving the money. That if I'm making a specific statement that kindly adjust this amount against that bill, then that will prevail. If no such situation is there, then the chance is given to the creditor. If even that is not availed, then order of time. The first bill will get settled first, the later one secondly. Okay, appropriation towards debts in order of time. Okay, ओके जी, चलते हैं आगे. Next is, sir, breach of contract. Breach of contract. What is breach of contract? Breach of contract means when you are violating the terms and condition of the contract, that is known as breach of contract. That is known as breach of contract. Now, breach of contract is of two types: actual breach or anticipatory breach. Anticipatory breach is such a situation where the promiser, sorry, where the promiser has put himself in such a situation that it is looking like that the contract is impossible to perform. That is known as anticipatory breach. Under such eventuality, the promisee is having two options. Either he can treat the anticipatory breach and resign the contract immediately. Resign the contract immediately. Or second option, he may not put an end to the contract immediately, but wait for some time, and till the time anticipatory breach will become actual breach, and make the contract alive till the time actual breach is being made. Actual breach has been made. Okay. With this, we are doing this important topic, subsequent impossibility. Sometimes at the time of making the contract, there was no such condition, but after such period of time, the contract becomes impossible to perform due to frustration of subject matter. Frustration of subject matter. That means subsequent impossibility. Rahul Jain sir booked the Taj Palace for his party, for his party to be held on 26th of November. Now, as the ill luck would had it, on 26/11 there was a terror attack at Taj Palace, and the banquet hall and the entire hotel got destroyed. This is known as frustration of subject matter, and the contract has subsequently impossible to perform. Therefore, the contract becomes void. The contract becomes void. Okay, okay, understood, understood. Okay, now one thing you will need to keep in mind, guys, giving you a very interesting example. Supposedly Rahul Jain is a tomato dealer. Now I entered into a contract with Kisan Tomato Ketchup, whereby I will supply them tomatoes worth rupees at the rate of 50 rupees per kg on a some future date. But during the intervening period, the prices of tomatoes got really high, say 150 rupees per kg. The prices got so high. Is it impossible to perform? No. आपने ये बात याद रखनी है, mere commercial difficulty will not fall under the category of impossibility. टमाटर तो मिल रहे हैं ना, चाहे 150 रुपए किलो मिल रहे हैं. दिस इज द कॉन्ट्रैक्ट. प्रॉफिट होना लॉस होना तो इसी में होता है. किसान विल गेट tomatoes at the rate of 50 rupees per kg from Rahul Jain because it was a contract. अगर ये 30 रुपए किलो हो जाते तब भी तो राहुल सर 50 रुपए में बेचते. Profit or loss is a part of the game. So mere commercial difficulty is not termed as impossibility. Is not termed as impossibility. Understood? ये चीज याद रखना है. Now here 64 and 65 is coming, that when a contract is voidable or has discovered to be void or becomes void, in that situation restoration must be done. Restoration means when you are putting the parties to the situation pre-contract situation में जब आप parties को डाल रहे हैं, that is known as restoration. Okay, next sir, when there is a breach of a contract, what is the remedy? Like हम torts में पढ़ते हैं ubi just ibi remedium, where there is a right there is a remedy. Similarly, when there is a breach of contract, there is a just a second. When there is a breach of contract, there is a right to claim damages. There is a right to claim damages. Damages of multiple situations. Number one, general damages, special damages, exemplary damages, which we say vindictive as well, and nominal damages. Now, one thing you need to keep in mind in the case of Hadley versus Baxendale, while considering damages, two offshoots need to be considered: that remoteness of damage, remoteness, and quantum. Quantum. Remoteness and quantum. That means under damage in the general situation, only those damages will be awarded which has been arising out due to the direct consequence, proximate consequence of the breach of contract. That means the defaulting party is not liable for the damages which are remotely connected with the breach of contract. Number two, a measure of damages should be considered by keeping different factors in consideration, which we say is a in the case of Hadley versus Baxendale. Now, exemplary damages are given only in two situations. Number one, when there is a failure to fulfill promise to marry. Promise to marry. If you do not marry the person to whom you have promised, then exemplary damages can be given, or a refusal to wrongful wrongful dishonor of check. Wrongful dishonor of check. If a bank has wrongfully dishonored the check, then in such an eventuality, the exemplary damages may be given. Okay. Now, so sometimes the situation is this, that damages are not sufficient. We do not want damages. Supposedly, Ankit entered into a contract with Rahul sir that, sir, please give a rapid revision batch for my exams just prior day. Rahul Jain sir is not giving that. I said take compensation. Now, Ankit is saying, sir, compensation is not enough because tomorrow I am having my exam. So how what I'll do with compensation? Now, in that situation, he may go for specific performance of injunction also under the specific relief act. Under specific relief act. Okay. Number two, suit of quantum merit. Suit of quantum merit. Under suit of quantum merit is, see, the general rule is the entire money will be paid only upon the fulfilling of the entire contract. For example, Rahul Jain sir booked a fully furnished flat with Sushma developers. With Sushma developers. Now they say, and 1 crore rupees flat. They are saying, sir, 80% work of the flat is done. We are giving you the possession. Remaining 20% we cannot do due to certain reasons. So you pays 80 lakh rupees. Rahul sir is saying, no, no, I booked a fully furnished flat. I will not accept this half ready flat. Sir, तभी हम we are demanding only 80 lakhs, not the entire money. No, no, that cannot be done. This is the general rule. Now let us turn the table. Now Rahul Jain is saying to Sushma that don't complete those entire flat. I will do it by my own. In that eventuality, Sushma developers can claim 80,000 because breach of contract is done by Rahul Jain. So there can be a suit of quantum merit that whatever money, whatever the job is done, you pay accordingly. You pay accordingly. Okay, understood. This is a minor and tricky point which you need to keep in mind. Okay, give me a okay. यहाँ तक कोई doubt? Any doubts up to here? Any doubts? Okay, चलते आगे. Next is quasi contract. Quasi contract. Quasi means partial, half, adha. Now there are certain situations where the parties are not expressly entering into a contract, but these contracts have been created due to some circumstances. Due to some circumstances, this contract has been created. Now, how this contract has been created, sir? Quasi contract will be created when they are an unjust enrichment at the expense of another. At the expense of another, they will make a quasi contract. For example, necessary supply to the minor, wrongful getting a payment through Google Pay, responsibility of finder of lost goods. If a person is enjoying non-gratuitous act, some person is getting an undue benefit due to mistake or coercion, then this is known as quasi contract. Now, guys, one thing important when we are talking about section number 68 regarding necessity supply to the minor or incompetent person, इसमें आपने एक चीज याद रखनी है, which many of people misses out. Read the second line, which is saying, or to anyone to whom such incompetent person is legally bound to support. Supposedly, Rahul Jain is helping Mrs. Abhishek. Abhishek is my friend who is lunatic. Who is lunatic. Now, legally, Abhishek is duty bound to maintain his wife and children. But Rahul Jain is maintaining them. Mrs. X is not lunatic, but she is a wife of Abhishek. So section 68 will fall over here also, and Abhishek's property, Abhishek estate is bound to be adjusted to be reimbursed up to me. Okay, so you need to keep in this thing in mind. Number two is 69 section, which is talking about reimbursement. When we are talking about section number 69, that when a reimbursement is there, the person who is making the original payment must be interested in giving the payment. Number two, the other person must be bound by law. Mother person must be bound by law. If these two conditions are satisfied, then the defaulting party is liable to reimburse that amount. reimbursed true amount. Okay. Okay, any doubts up to here? Okay. Now, sir, next topic is, which is very important, finder of lost good. See, when you find the lost good, first and foremost criteria is that it is your responsibility to find the true owner, and you become, and your status becomes of a bailey. Your status becomes of bailey. Now, if by due diligent efforts the original owner is not found, or it is found after some much time, so during that intervening period, whatever reasonable expenses you have incurred upon preservation of those goods, you are entitled to claim that. Now, sometimes the product is of such a nature that it is losing its value, perishing in nature, or the amount of reimbursement is more than two-thirds of its value, then the finder of the lost goods is having a opportunity to resell those goods in the market. In the market. Okay. Okay, understood. Chale aage. Just give me a second. By the time, please see to your notes. If you have any doubt, please see. I'm waiting for you for a moment. Yeah. Any doubts, guys? Chale aage. Guys, please mark section number 68 and 71 very important for pre. 68 and 71 very important for pre. Give me a thumbs up to go. I'm waiting. Shaktija, Manish, Ankit. Any doubts? ओके चलिए बढ़िया बढ़िया चलता. ओके नाउ वी आर हेडिंग टुवर्ड्स, जिसको आप अपनी भाषा में कहते हैं कॉन्ट्रैक्ट पार्ट टू. Now, under contract part 2, these are basically special contracts. Three chapters: indemnity and guarantee, bailment and pledge. Third is agency. Generically, these three categories are clubbed, are just like offshoots of a basic thing that is known as contract. That is known as contract. Basically, these three categories are the special contracts. These are some special contracts. Okay. Now, what is indemnity? Indemnity is when you are making good to the loss of the person. Sir, I know indemnity, but I get confused upon between indemnity and guarantee. The best part is Rahul Jain, Abhishek, and a shopkeeper. And a shopkeeper. These three are parties. Rahul Jain said to shopkeeper, "Let Abhishek take the goods, I will pay you. Let Abhishek take the goods, I will pay you." This is known as indemnity. This is known as indemnity. Number two situation, when Rahul Jain said to a shopkeeper, let Abhishek take the goods. If he do not pay, then I will pay you. If you do not pay, then I will pay you. That is known as guarantee. That is known as guarantee. Under contract of indemnity, a contract is there whereby one party is promising to save the other party from the loss caused by the promiser himself or conduct by other person. Now, one thing you need to keep in mind, under contract of indemnity, under Indian law, they are covering only losses occurred due to human agency. Human agency only. Only human agency. They are not covering the concepts of circumstances. They are just covering the concept of human agency. However, under English law, they are including human agency as well as the other contracts. Okay. Okay. As far as contract of guarantee are concerned, there are three parties. These are three parties: shopkeeper, Rahul Jain, and Abhishek. Abhishek will be known as principal debtor. Shopkeeper will be known as creditor, and Rahul Jain will be known as श्योरिटी, जिसको आप आम भाषा में गारंटर भी बोलते हैं. He is known as surety. In contract of guarantee, there are three contracts. There are three contract. Contract number 1, 2, and 3. How? In contract number 1, Abhishek is liable towards shopkeeper. Under contract number 2, if Abhishek fails, shopkeeper can proceed against Rahul Jain. Under contract number 3, if Rahul Jain has been proceeded by a shopkeeper and he has made this contract, he has made him paid, then Rahul Jain can get a right of indemnify from Abhishek. From Abhishek. Basically, in each and every contract of guarantee, there is a concept of indemnity automatically. हर कॉन्ट्रैक्ट ऑफ गारंटी में एक इंडेमनिटी का कॉन्ट्रैक्ट तो आएगा ही आएगा. ओके. A guarantee may be oral as well as written. The guarantee may be oral as well as written. Okay. सर इसमें कंसिडरेशन क्या है? Now, as per section number 127, this is very important. Sometimes the question comes. As per section 127, the benefit of the principal debtor, the benefit of principal debtor will be considered as a sufficient guarantee. A sufficient consideration is a sufficient consideration. Okay, understood? Now sir, the very important topic is, sir, when the surety is making a payment to the creditor, then he is also having a right that whatever the security was given to him should be supplied to him. Basically, the surety will step into the shoes of creditor. The surety will step into the shoes of creditor, and he will be having all the rights, whatever the rights were given to the creditor. To the creditor. Now, there are certain situations. Just a second. There are certain situations where the surety is discharged. The surety is discharged from the liability. What are the situations? Just see. Let me see. Principal debtor, creditor, and surety. Now, there are certain situations that surety is free from its liability. Number 1, when there is a continuing guarantee and surety has revoked his guarantee. Now, but to note that surety can revoke his guarantee for the future transactions only. लिख लीजिए जहां पर भी लिख रहे हैं, for the future transactions only, that the guarantee may be revoked. The surety cannot revoke its guarantee for the past act. वो तो हो गया सर. Number 2, if the surety is died and there was no specific mention in, or there is no contrary contract, then the guarantee is automatically revoked. As per 131, in case of death of a surety and in absence of any contract to the contrary, it will be taken as revocation of guarantee for future transactions. अगर कोई continuing contract है और कोई contrary agreement भी है, तभी आगे LRs को liable किया जाएगा, otherwise not. Next is by variance in terms and conditions of the contract without the consent of the surety. See, surety is the one who is ultimately liable. So, उसका consent होना जरूरी है. Now, by release and discharge of principal debtor, or like when you are making a compounding with the principal debtor कि मैं तेरे ऊपर केस नहीं करूंगा, surety को पकड़ते हैं. No, this thing should not be there, because the primary liability was of the principal debtor only. The primary liability was the principal debtor, and if the creditor is compounding with the principal debtor, then it will amount to discharge of surety liability. Guys, one thing important to note, that that mere forbearance to sue is not enough. Mere forbearance to sue is not enough. It should be compounding. It should be compounding. Okay. Now, last is when the creditor is doing certain act or omission which is impairing surety's eventual remedy. What is the eventual remedy of a surety, sir? The securities which were pledged. Now दिस अगर इससे ये श्योरिटी जान के घुमा देता है, प्रिंसिपल डेटर को वापस दे देता है, if he is returning to principal debtor, then ultimately it is hampering the rights of surety, and surety is discharged. Surety is discharged. Now surety is discharged, but there are certain rights of surety जो हमने करे. It is as against principal debtor, right of subrogation, that for you now I am the creditor, give me my money. Against indemnity, that whatever losses I have incurred due to your fault, I am having a right to get indemnified. Against the creditor, for security, whatever securities were with you, give it to me. Against the co-surety is that whatever the situation is, we will join it. Sir, can there be more than one surety? Yes, there can be more than one surety, even if they do not know each other. Sir, supposedly Rahul Jain sir took a loan of rupees 1 lakh. This is the question. A, B, C, D, what four sureties? How will they contribute? So the general rule is 25,000 each. 25,000 each. Okay. Supposedly D has given a surety up to 20,000. D has given a surety up to 20,000. Then in such an eventuality, 20,000 and the remaining 80,000 shall be taken care by them in ratio of 1/3. Sir, supposedly C has given a surety of again 20,000. Then they will contribute 20 each. Remaining 60, 30, 30. 30, 30. So they cannot charge from more than the upper limit. This amount of surety will be acted as upper limit. Will be acted as upper limit. Okay, understood? चले आगे चलते हैं सर. Any doubts up to here? Please ask. Then we'll start a new chapter. Bailment and pledge. Quickly. Quickly. No, sir. Okay, chalte. Next topic is bailment and pledge. Okay. Bailment and pledge. What is bailment? Bailment is basically where it consists of delivery of the goods. Guys, pay attention the word delivery. Delivery means possession. We are not talking about ownership. We are talking about possession. Bailment is a contract whereby the possession of the goods have been transferred from one party to another for a particular purpose. And that has to be returned or disposed of accordingly after the fulfillment or time of that particular purpose. Now it can be for money as well or without. If it is without money, that is known as gratuitous bailment. For example, Abhishek came to my house that, Rahul sir, I want to go to a wedding. Can I borrow your car? Now I am not going to charge something from the car. Now I have given, then also it is a clear contract of bailment, a gratuitous bailment. Number two, Abhishek contracted Zoom car for going to a marriage. Now Zoom car has delivered them a car and they are charging 2,000 rupees per day, supposedly. Now they are charging money. This is also a contract of payment. Now, upon the fulfillment of the purpose was to going to the marriage. After coming back, the Abhishek has to return my car as well as to the Zoom car. Delivery back of possession. The person who is giving the bailment is known as bailer. Bailer. He will be known as bailee. He will be known as bailee. Okay. 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 Nice. Now, sir, in the concept of bailer and bailee, there should be the delivery of possession, and after that, the possession has to be returned back. Now, sir, bailee is under certain duties, under certain duty. सर सबसे पहली बात तो वो गाड़ी का ध्यान रखना है. Duty to take a reasonable care of the goods bail. That means गाड़ी अपनी समझ के चलानी है एज अ प्रूडेंट मैन वॉट एवर दी यू वुड हैव टेकन द रिस्पॉन्सिबिलिटी एज इट वॉज योर कार then it is your duty to take a reasonable care of the goods paid. Number two, you are not authorized you are not allowed to make an unauthorized usage. मेरे से गाड़ी लेकर के आगे किराए पे चढ़ा दी. No, you are not allowed to make unauthorized usage of the car. Next, if you are using it for unauthorized usage, then I may claim compensation and I can also terminate the bailment. Next, you are not allowed to mix my goods with your own goods. Supposedly, in the terms of dresses, fabrics, it happens. And if there is a mixture of goods without my consent, then if the goods can be separated, whatever the cost of separation is there, bailee will be responsible. If it cannot be separated, then bailee will be liable for the damages cost. Okay. Last, you have to deliver back the delivery back the goods. Now, not only the goods, any increase or profit, whatever it is, you have to return it to me. Now, Rahul Jain sir went to a party and gave my hen to Abhishek for few hours. जब मैं आया उस मुर्गी ने 6 अंडे दे दिए 6x. Now Abhishek is entitled to return the hens as well as those 6x. Abhishek cannot say वो तो मैं खा गया. No, 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 no. सर आपने मुर्गी दी थी मुर्गी वापस दे दी अंडे में खा गया. No, no, no. You have to give me the hen as well as the whatever the increase or profits were there. Okay, so these were the rights, these were the duties of bailee. Apart from this, there are certain rights as well. That, sir, for keeping your henna, I had to maintain her and give her feeding and etc. 500 rupees. Whatever necessary expenses were made during the bailment, he is having a right to recover those. If certain loss has been occurred due to the fault of bailer, the bailee is having a right to recover those compensation as well. Next point is very important, lien. 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 What do you mean by lien? Lien means right to retain. Right to retain. Right to retain is known as lien, and lien is of two types: general lien and particular lien. General lien and particular lien. When we are talking about general lien, see, Rahul Jain went to Manish Malhotra, my regular tailor, he's my regular tailor, and asked to stitch a sherwani. Fabric was given by me. He has to give us stitching cost. Now he raised a bill of 10,000 rupees. He raised a bill of 10,000 rupees. I did not pay the 10,000. I said, okay, I will give you 8,000. वो वापस नहीं देता शेरवानी. Can he do so? Yes, he can do so because he is exercising right to general lien, because his right to particular lien, because I did not pay the amount for that particular transaction. Supposedly, Manish Malhotra said, you are already having a previous outstanding amount worth rupees 30,000. Can he exercise lien now? No. He can exercise right to lien for this transaction only, not to any previous transaction. Not to any previous transaction. He can exercise lien for this transaction only. Okay, understood? Otherwise वो जनरल लियन बन जाएगा. Otherwise वो जनरल लियन बन जाएगा. General lien is allowed to only few categories. Number one, finder of lost goods, जो हमने अभी पढ़ा. Pawnee's lien, agent's lien, unpaid seller under Sale of Goods Act, and partner's lien. Partner's lien under Indian Partnership Act. So by these people only that under by these people only, this right to particular lien has been granted. However, as far as general lien is concerned, general lien is concerned to bankers, factors, wharfingers, attorneys of high court and policy brokers. ये पांच कैटेगरी पर्टिकुलर लियन की, ऊपर की पांच कैटेगरी जनरल लियन की. Particular lien can be exercised by, I am repeating, particular lien can be exercised by pawnee, finder of lost goods, agent, unpaid seller, partners lien. General lien can be exercised by banker, factor, wharfinger, attorneys of high court, policy brokers. Okay, याद रखना है पर्टिकुलर लियन कब इस्तेमाल होगा, जनरल लियन कब इस्तेमाल होगा. ओके, अब ध्यान से समझिए. कैन अ बैंक एक्सरसाइज लियन ओवर मनी? आंसर इज नो. बैंक कैन नॉट एक्सरसाइज लियन ओवर मनी. Section 171 is saying that bank can exercise right to lien only upon papers, securities or other goods which are deposited with the bank. Money is not a good. मनी के ऊपर लियन एक्सरसाइज नहीं किया जा सकता. मनी के ऊपर एक्सरसाइज नहीं किया जा सकता, इस चीज को याद रखना है. ओके, नेक्स्ट टॉपिक इज व्हाट इज प्लेज. व्हाट इज प्लेज? प्लेज क्या होता है सर? प्लेज इज अ स्पेशल टाइप ऑफ कॉन्ट्रैक्ट ऑफ बेलमेंट ओनली. प्लेज भी एक तरीके से बेलमेंट का ही कॉन्सेप्ट होता है, वेयर बाय द गुड्स आर delivered as a security, as a security of a debt or for performance of a contract, or for performance of a contract, that is known as contract of pledge. That is known as contract of pledge. होता एक तरीके से वो भी बेलमेंट ही है, वो भी बेलमेंट ही है, लेकिन उसके अंदर वो एक पर्टिकुलर डेट की पेमेंट के लिए रखा जाता है. ओके, understood? Any doubts? Any doubts, guys? Please say yes or no. I'm waiting. Otherwise, we'll go for next chapter. Write it in the chat box if you have any doubt. No, sir. Okay, ji. Agent, agency. Next topic is agency. What is agency? Again, agency is a special type of a contract where there is a principal and there is an agent. Agent is acting on the behalf of principal for third party, but ultimately a contract is formed between principal and third party. They are legally bound. Principal is bound towards third party for the acts done by his agent. For the acts done by his agent. Number one. अब दो तीन पॉइंट्स याद रखने हैं. Principal should be competent to contract at the time of dealing. At the time of dealing, there should be an existence of the principal. There should be an existence of the principal, and principal should be competent to contract. Principal should be competent to contract. Number one. Agent may not be competent to contract. Under 184, एजेंट में नॉट बी अ कॉम्पिटेंट टू कॉन्ट्रैक्ट. इसीलिए हमने लिखवाया था कि माइनर कैन बी एन एजेंट बट माइनर कैन नॉट बी अ प्रिंसिपल. माइनर कैन नॉट बी अ प्रिंसिपल. एजेंट में नॉट बी अ कॉम्पिटेंट टू कॉन्ट्रैक्ट. नो कंसिडरेशन इज नेसेसरी टू क्रिएट एन एजेंसी बाय 185. इन दोनों के बीच अगर कोई कंसिडरेशन नहीं भी है तब भी वो एक वैलिड एजेंसी माना जाएगा. इफ देयर इज नो कंसिडरेशन बिटवीन अ प्रिंसिपल एंड एजेंट, then also it is a valid agency. Okay, तीनों पॉइंट्स याद आ गए. नंबर नेक्स्ट. सर, what are different type of agents? Different type of agents are auctioneers, factors, brokers. One important point, sometimes it comes in a pre-paper. What are del credere agents? Del credere agents. Del credere agents are those agents whose job is not only limited towards the entering into contract, but also their job is to make the third party to perform the contract. He is paid extra just for the purpose of ensuring the performance of the contract. That is known as del credere agents. For example, Rahul Jain sir sold his flat to Abhishek. Now, Shantanu is a Del creditor agent. Shantanu job is to make sure that I am being given the money on time and the registry of the property is done. This is known as Del creditor agent. Okay, सिर्फ डील कराना काम नहीं था, आगे उसको फुलफिल कराना भी काम है. Okay, understood. Okay, sir, how this agency can be created? This agency can be created first of all by principal's express authority or implied authority, that and I am giving you this task to be done, then this can be done. Or in emergency situation, or by way of estoppel, or by way of ratification, then can be done. Sir, what do you mean by ratification? Sometimes the agent act on behalf of principal without having an authority. But now principal has to choose that either he is disowning the act or he is approving it. If he is approving it, then he is saying to be ratifying it. He is said to be ratifying it. Now, for a valid ratification, the act must be there. At the time of act, the principal should be in existence and competent to contract. The ratification may be expressed or implied, and the ratification should be done with full knowledge of facts and the whole transaction. ऐसा नहीं है आधी transaction हाँ कर ली आधी नहीं कर ली. No, the ratification should not be done for the act which is injurious to third parties, and which should be done within the reasonable time. Within the reasonable time. Sir, if supposedly this contract was made on 1st of October and ratification was done on 1st of November, what should be the date of contract? The act was 1st of October, ratification was 1st of November. What should be the date of contract? The date of contract will be the date of act itself. The date of act itself. This thing will be the date of act itself, not the date of ratification. This is known as doctrine of relating back. Doctrine of relating back. So if there has to be ratification, the ratification is to be done, and the date of act will be known as date of contract. Date of contract. Okay. Now, sir, there are two concepts: agent and sub-agent. Sub-agent. A has kept B under his authority. Now, sub-agent is a person who is appointed by an agent. Now, the general rule is that the agent cannot delegate his authorities. But there are certain situation, exceptional situation, where sub-agent can be appointed. When there is a custom of trade, when there is no requirement of personal skill, where the principal has specifically agreed, or where the nature is such that you need to keep sub agents. Now, in that situation, the sub agent is responsible to agent, and agent is responsible to principal. Agent is responsible to the principal. Okay. Here we are doing a concept of substituted agent. There is a difference between sub agent and substituted agent. Now, in this situation, principal has casted a duty upon an agent to find his replacement. To find his replacement. He is known as substituted agent. He will step into the shoes of agent, and this agent will go out of the picture. He will go out of this picture, and ultimately now principal, substituted agent, and this third party are in the game. These three parties will be in the game. Agent will out of the picture. His job was to just appoint the substituted agent. उसके बाद वो क्या करता है क्या नहीं करता उसकी जिम्मेदारी नहीं. When an agent has been appointed, it is the duty of an agent to follow the principal's direction for the conduct of smooth business, and whatever the he has to communicate. While he is communicating, he has to show proper skill and care while entering into the deal. Whatever the accounts are there, he has to render the proper accounts. He must not use the account for his personal account, and if there is a personal account, he should refer it back, and whatever he is claiming, he has to return it to the principal. He has to return it to the principal. Okay. As far as his duties, as far as his rights is concerned, sir, principal is having certain duties towards agent. That first of all, right to remuneration. Whatever the lawful remuneration has to be paid to the agent has to be given. If he is not getting that remuneration, he can hold the sums whatever he has received on behalf of principal and deduct what was rightfully claimed. Rightfully claimed. Whatever lawful acts the agent has done, he has a right to get indemnified. He has a right to get indemnified. Okay. And if due to neglect of the principal, if the agent has suffered any loss, he is having a right to compensation. He is having a right to compensation. Okay, guys. इसके बाद एक इंपॉर्टेंट टॉपिक करने लग रहे हैं, यहां तक बताइए कोई डाउट हो तो. गिविंग यू 1 मिनट. लास्ट टॉपिक रह गया हमारे सिलेबस का. एनी डाउट्स? गिविंग यू 1-2 minutes. चेक इट आउट एंड आस्क मी. Any doubts? Please give me a thumbs up. Okay, I guess no doubts. चलते हैं. Sir, what? Just a second. Yeah. Sir, what is the relationship of principal and agent with the third party? Sir, the general rule is agent is acting on behalf of principal to make principal liable with the third party. He is acting on behalf, but the liability is derived in this situation. Now, this is the situation, but there are certain situations where there is a personal liability of the principal agent, where there is the personal liability of the agent. Now, under what situation the principal agent is having a personal liability? Number one, when the principal was a foreign principal. When a person will be a principal will be a foreign principal. The logic behind it is it to avoid the hardships to the third person for pursuing a case against principal, then you may catch agent. Number two, when the agent is an undisclosed principal, that when the agent is acting on behalf of an undisclosed principal, when the principal is undisclosed, then you make agent liable. You may make agent liable. Number three, when there is a situation the principal is disclosed but cannot be sued due to some technical or legal immunity, he cannot be sued, then the ultimate liabilities of the agent. Ultimate liabilities of agent. Now, when they have specifically agreed, agent has specifically agreed that it is my responsibility, then it is my responsibility. Under that situation, agent will be personally liable. In this situation, here comes of pretended agent. Pretended agent. I told you, when there is a concept of ratification, principal may either choose to ratify it or disapprove it. अगर ratify कर लिया तो बात ही खत्म होगी. If he disapprove it, the agent will become principal agent, and he will be personally liable. He will be personally liable. Okay. Apart from that, there is a concept of termination of agency. Termination of agency can be there when there is a revocation of authority by the principal. Principal may specifically by express or implied may give us instruction that you are no more required, go back. Now if there is a premature revocation, in this case the principal is liable to compensate. Principal is liable to compensate. Next, when you are giving a revocation notice, it should be given a reasonable time. Reasonable notice should be there. And a termination of agency also terminates sub agency as well. Also terminates sub agency as well. Sir, यहाँ तक तो समझ आ गया. This is known as revocation of agency. Sometimes agent can also renounce the contract. मुझे काम ही नहीं करना है. Then the agent may renounce the agency contract of agency. Okay. Sir, what if the task is completed? Yes, by the completion of business of agency, this is known as the agency is terminated. If case of death or insanity of principal or agent. In the case of death or insanity of principal or agent, the agency is terminated. The agency is terminated. But it is the duty of an agent, in case this agency is terminated by the death or insanity of the principal. Agent is under a duty to take care of the business on behalf of representatives of his late principal, and all the reasonable steps should be there for protection and preservation of the interest. क्योंकि उसको रोजमर्रा के काम पता है, इसीलिए उस ही इज अंडर ड्यूटी बाउंड, ही इज अंडर ड्यूटी टू टेक केयर इट. लास्ट इज फॉर insolvency of the principals. Guys, now pay attention here, it is a tricky top point, that insolvency of a principal is a ground for termination of agency. Insolvency of agent is not a ground. The logic behind is that ultimately it is the principal who is liable. So insolvency of a principal is a ground for termination of agency. It is not a ground for, it is not a ground in case of insolvency of an agent. Okay, understood. So basically this all you have to do in the case of agency. There is one thing, one it in the chapter agency, please write it down, section number 186 and 201. 201, that is termination of agency, is very important. Termination of agency is very important for your pre-paper. Write it down. Okay, with this we calls for the end of your revision of Indian Contract Act, giving you 5 minutes. Just quickly scan your notes, scan your notebooks, job papers, bare acts, books, whatever it is. I'm sitting here for 5 minutes for your doubt session, for your question answers. Last 10 minutes I spared for you only. Okay, please ask one by one. Just write your questions in the chat box. I'm reading the chat box. Any particular section, any particular topic, any particular case, any concept. Okay, and those who do not have any doubts, just write out the feedback and how did you feel, any suggestion in the chat box. Waiting for your questions. Write down the feedback as well, guys. Any suggestions? No doubts, guys? Please write yes or no. Thank you, Ash. Thank you so much. Those who do not have any doubts, just write a feedback or suggestion. Okay. All the best for your exams. Okay. I guess let's call for it.